how are assets divided in New York State?
Generally speaking, in a long-term marriage, marital assets are divided 50-50. That's a general rule, though there are many exceptions to that general rule. One major exception is just the definition of marital property. So marital property is generally any property that is either acquired or accrues active value during the time of the marriage. Active value being was marital money put into that asset, either property or investment account or retirement account. The other thing to note is title. So under New York state law, title does not matter as a general rule. So it does not matter whose name is on the house, whose name is on the account, whether it be an investment account or retirement account. The only thing that does matter, again, as a general rule, was the property acquired or accrued active value during the time of the marriage. So that's the first thing to kind of start off with. The next thing is all of the exceptions. So one could make an argument that one party or the other has put in more to the accrual of that particular asset. So an example being a business that one party has. And let's say they put in all the blood, sweat, and tears to accrue value to that business. The law, generally speaking, says that they should walk away with the vast majority of the value of that business. But even then, there are exceptions to that general rule. So, businesses are oftentimes divided in some percentage like 10, 20, 30%, unless there is proof of some kind of substantial contribution of the non-titled spouse to the value of that business. The next thing is in terms of infusion of separate property into assets, whether it be a house or an investment account or a retirement account. Number one, the separate property credit has to be backed out. So in other words, any premarital portion or any inheritance that went into a particular account, that has to be backed out. I have cases where it results in a very convoluted fact pattern. So for instance, one party could say, well, I had assets at the time of the marriage, and I want a separate property credit. But then during the marriage, they either, on the one hand, added their spouse's name to the asset, whether it be a property or financial account, and or B, they put marital money into that house or that financial asset. If they did either one of those, the law says they at least arguably commingled that asset. In other words, they joined premarital money with marital money. Then there's an exception to that where the party seeking the separate property credit could say, well, I only did so for convenient purposes only. So in other words, example being, I had $100,000 going into the marriage in a particular account. I took that, or some of that money out of that account, and I put it towards the down payment on a house. And so I want to argue that I should get that money back. But then let's say the party took the money out of the premarital account and put it first into a marital account, and then from that marital account, cut a check at closing for the house. Well, then the other spouse is going to argue that you commingled the premarital funds with the marital funds the minute you put it into the joint account. And then the burden then shifts to the other party to prove, yeah, but I did so only for convenience purposes. It only hit that joint account for a short period of time. and then I cut the check from there at closing. That spouse claiming the premarital credit has what's called a burden of tracing. So they have to trace all the lines of financial infusion of that separate property. So they have to show that it was in there as of time of marriage. They have to show the statements at the time they move that money from the separate property account to the marital account. Then they have to show the statement from the marital account to the closing, and usually show the closing statement as well. And even then, it's discretionary on the part of the court to grant them that convenience defense. So it can sometimes get very convoluted in terms of how assets are divided, which is why most parties are not cognizant at all of the nuances of marital versus separate property and how tangled the web could get. And that's why you want a good attorney that is cognizant of all those nuances to be able to advise you and assemble the proper evidence to prove your claim.